Welcome, lovely viewers, to another exciting video. It's a pleasure to have you join us as we uncover the secrets of Ministère Public France. In French law, the Ministère Public or le parquet is the authority charged with defending the interests of society and of the application of law. It is primarily made up of magistrates, but is sometimes represented by other persons such as police officials. Its magistrates can be referred to as standing magistrates, as opposed to magistrates du siège, magistrates of the seat. Its closest equivalent in some English-speaking countries is the office of the Director of Public Prosecutions and the Attorney General in others. The term Ministère Public translates literally as public ministry, and that institution can exercise a public action public in penal infractions that cause a disturbance of the order public, and can also initiate prosecutions or non-prosecutions. It can intervene in all jurisdictions of the judiciary, but has never really exercised the same role in the administrative areas, except for financial jurisdictions financières. In this section, we'll be exploring terminology. In France, the Ministère Public, in the person of an Attorney General, a procureur de l'ordre public, or one of his substitutes or representatives, is designated as le parquet in legal jargon. The word parquet itself may have stemmed from the Old French, where it meant a small park or enclosure. The term parquet goes back to the medieval expression parquet de gens du roi. The origin of this use and meaning of the word is not known with certainty, but the most probable hypothesis is that these magistrates were separated from the magistrates du siège in a sort of park. The location of the Ministère Public has been called the parquet because in the Great Chamber, la Grande Chambre of Paris, the enclosure delimited on three sides by the seats of judges and on the fourth by a bar or handrail. This heart of the room, a closed and dedicated space sacre, a small park or parquet, that the people of the King les gens du roi crossed to take their places, and where the gens d'armes, gendarmes, came forward to relate the findings of their investigations, to erect interesse the prox verbal. The name standing magistracy, magistrature devout, comes from the fact that Ministère Public magistrates formerly stood to speak, notably when prenant les requisitions, asking for a sentence, unlike the magistrates du siège, magistrates of the seat, who remain seated for their entire hearing. Prepare yourself for an eye-opening discussion on history in the upcoming portion of this video. The Ministère Public first appears as a concept at the end of the 18th century, when the kings of France caused their interests to be defended by procureurs, or prosecutors, who little by little put themselves exclusively at the service of the kings. The parquet modeled itself little by little with procureurs, prosecutors, advocates, lawyers and substitutes, designations which remain in contemporary French justice. Prior to the French Revolution, the Ministère Public was embodied by officers called the gens du roi, king's men, so that the Attorney General of the King was the key role of the parliaments of the Ancien region. The question of whether to keep the Ministère Public arose at the time of the Revolution, but this was resolved in the affirmative by the law of the 16th and 24 August 1790, notably in Article 8 of Title II. The First Republic reprised the idea as the accusateur public, or public accuser. Until 1970, jurisdictions existed which had a parquet, in general the penal jurisdictions and the civil common law jurisdictions, and jurisdictions with no parquet existed as well, the jurisdictions d'exception non-repressives such as the Council de Prud'hommes, for example. Article 3 of Law No. 7613, the law of the 10th of July 1970, authorized the prosecutor of the Republic to exercise public action before all first-degree jurisdictions. The drive to install a Ministère Public before administrative jurisdictions other than the Cour des Comptes was translated by the ordinances of February 2 and March 12, 1831, which created the function of government commissioner before the concealed stat. Not until 1862 were government commissioners introduced to les conciles de préfecture. Given that administrative justice works differently, the absence of hierarchy between the commissioners and a more rapid passage from the function of commissaire du government to that of judge, These persons never really exercised the role done ministry public, except in comparison to a public minister. Ministry public of the Cour de Cassation. The government rebaptized rapporteurs publics in 2009. Moving ahead, let's uncover the hidden gems within indivisibility of the parquet and discover their significance. One of the specifics of the parquet is that it is indivisible. Each member represents the whole and the members are thus interchangeables. Any action by a member commits the entire parquet. In a trial, the magistrates of the parquet may mutually replace one another without stopping the proceedings, which is forbidden to the magistrates' dosage results in the case of nullity of the judgment. As we enter this new phase, let's analyze non-responsibility of the parquet from different angles and evaluate its significance. Another specific is the non-responsibility of the parquet. A magistrate of the parquet is responsible only for his own mistakes but cannot be assigned court costs as another plaintiff might after losing a trial. He cannot be prosecuted for either injury or defamation caused by what he says in a hearing. Personal faults tied to public service can on the other hand be prosecuted by virtue of the state's power of recourse, but only in front of the civil chamber of the Cour de Cassation. Let's now shift our focus to organization and personnel and explore the ways in which it shapes our perspective. The magistrates who compose it are the same as those of the siège chair. Generally, a magistrate, in the course of his career, will carry out the functions of the chair as well as of the parquet. Notes for the table. Its composition varies with the jurisdiction. In police tribunals, the ministry public is represented by a substitute in the tribunal de grande instance for fifth-class contraventions and a commissaire de police, police commissioner of the place where the tribunal is located, an officer of the ministry public for the first through fourth classes of offence, and, on an exceptional basis, by the mayor of the municipality. In correctional tribunals, a prosecutor of the Republic assisted by an assistant prosecutor and the substitutes of the prosecutor according to the importance of the tribunal. In courts of appeal, there is a prosecutor general as well as attorneys general and the general substitute who make up what is known as the parquet general. In cas d'assis, the representative of the ministry public, called attorney general, is either a member of the general parquet or a member of the parquet of the correctional tribunal. In the Court of Cassation, one finds a prosecutor general, a first attorney general as well as attorneys general. This parquet cannot exercise any action public. It has a role similar to that of the rapporteur public before the Conseil d'État or Council of State. Special case, when the infractions concern the public roadways, the functions of the ministry public of a police tribunal may be filled by the departmental director of equipment or the agent designated by him to supplement him. This article is still in effect, but the departmental directorates have been replaced by the interdepartmental directors of roads directions, interdepartementals de routes. Before military tribunals, in time of war tribunal territorial de forces armes et tribunal militaire aux armes, the ministry public role falls to government commissioner. Brace yourselves for the next chapter, where we'll be dissecting ministry public's role. The role of the ministry public, which is to defend the interests of society, the public order and the application of the law, is exercised in three areas: an action public before a penal jurisdiction, an intervention before a civil jurisdiction, and the attributions administratives. Our focus now turns to exercise of public action in penal matters, an important aspect of our discussion. He represents the interests of society, and to do so he exercises an action public, in other words prosecution, as the plaintiff, intervening in the trial as a principal party. He can act both in the instruction and the judgment phases. The services of the police judiciary, or judicial police, are at the disposal of the ministry public for seeking out infractions, which allows him to decide whether or not to set off the action public. Welcome to the next segment, where we explore before administrative jurisdictions and its significance in our journey. In common law administrative jurisdictions, i.e. as opposed to specialist administrative jurisdictions, commissaires du government commissioners existed and were loosely related to the judiciary's ministry public, albeit their functions were closer to giving a general opinion on legal matters pertaining a case rather than actively defending the interests of society of the government, despite their name. Their transformation into rapporteurs publics in 2009 confirmed that they were not of the same nature as the ministry public. Furthermore, rapporteurs public has been confirmed to be fully independent and impartial in their functions. Get ready for a captivating exploration as we unravel the layers of before the tribunal de conflits and their profound significance. Article 6 of the Law of February 4, 1850 bearing on the organization of the Tribunal de Conflits provides that the functions of the Ministry Public will be filled by 2 commissioners of the government chosen every year by the President of the Republic, one from among the Maîtres de Rites on the State Council concealed stat, the other from the parquet of the Cour de Cassation. Le tribunal ne peut statuer qu'après avoir entendu les conclusions du commissaire du gouvernement art. For de la loi, si le rapporteur appartient au concealed stat, als le commissaire du gouvernement doit être un magistrat de la Cour de Cassation, et réciproquement art. 7 de la loi. Prepare yourself for an in-depth analysis of non-independence of the parquet and condemnation fronts in this section. The parquet is not considered an independent judicial authority in the meaning of Article 5 of the Convention de sauvegarde des droits de l'homme et des libertés fondamentales. The European Court for the Rights of Man condemned France in November 2010 for having conferred on it jurisdictional functions. In 2013 the law was again modified, eliminating the oral instructions transmitted par the Chancellery to prosecutors. At the same time, the European Court of Human Rights confirmed in a new verdict on June 27, 2013, Vasses et al. Versus France, that the French parquet cannot be considered a judicial authority in the sense of article of the Convention. If you found this video helpful, give it a like and share it with someone who might benefit from it.